Well, I think we need to do more episodes that teach lawyers or help lawyers, young lawyers, learn how to do direct examinations. And I thought that would be a good topic for us to discuss.
I thought it would be a good topic to discuss. You just co-opted my topic and took credit for it. I'm just going to call it like I see it. Okay, go ahead.
You guys are still spicy. You gotta.
Karen, I can't. I'll never win with you. There is never a win with you.
It's true.
Never win.
True. All right, so I'll tell you a story about. So direct examination is what we're going to focus on, and of the plaintiff or of lay witnesses. We won't do experts and we won't do cross in general, but we'll do direct of lay and plaintiff witnesses.
Okay.
Okay. So, and in criminal trials, of course, the accused almost never testifies. No. So you probably haven't had as much practice with your client testifying as I have. But I'll tell you this one story. I always can remember it, and I'm going to take you on my journey of under-preparing, over-preparing, and then how I prepare now. I used to over-prepare all my witnesses because I was trained as a defense lawyer, and we were trained to over-prepare on everything. So that was the rigor. I over-prepared. We would have lists, we would have practice sessions, and a lot of people still do that today. Yeah. When I started doing a plaintiff law, I still use that rigor. And what happens when you do that, in my experience as a lawyer that's like me, which I am more real, like I hate scripted, it sounded scripted. It was all correct. It caused an enormous amount of stress on the witness because they had to memorize all that and not make any mistakes. Yeah. And you ended up with very stilted testimony that was correct but not persuasive. Yeah. And as we all know from Polavera, trial is a matter of impression, primarily. So I did that for years because that's what I was trained to do and had to do as a defense lawyer, and went on to a certain extent. And then I kind of did the opposite, which is I did nothing, very little. I just assumed they already know what they're testifying to. They're supposed to speak the truth, and they should just do it. Well, that had some interesting consequences. And now I have a different approach, which I'll get to, but I'll tell you this one story of this one client. She was one that I'd actually prepared.
Yeah.
She had prepared. It was just a car accident case, and she was prepared. She knew it wasn't complicated. She knew her stuff. I had put her on as a witness. She had gone through her testimony. It wasn't flashy. It was fine. She did just totally fine. The defense lawyer got up and started cross-examining her, and before I knew it, my client was standing up like this, yelling at the defense attorney. The jury, I just watched the jury instantly hate my client.
Oh, boy.
Like, you cannot have your client yelling at the defense attorney. They're not supposed to be able to do that. Mm-hmm. And I'm sure that I had already told her, those are one of the rules, like, don't lose your temper. Oh, boy. And so the one thing that I was always good at was reading a room and acting quickly. So as soon as that happened, it was happening, and I was thinking, this is terrible. What am I going to do? So that's lesson number one, is you have to be in the moment. You can't be thinking about anything else. You got to be in the moment. And when you're in the moment in direct exam, you are in the moment with your client, but you also have to be sensing what's going on with the jury all at the same time, which can be difficult if they're to your side. I also don't believe in federal court, you're handicapped because you have to stand behind the stupid podium, which I hate. And I wish that they would grow up and get rid of the stupid podium. I hate the podium. It's a barrier. It's us versus them, and it is an artifice that I think is gross. That said, what you were trained to do when you went to trial class, or by my senior partners when I was a defense lawyer, was to always stand at the far end of the bar of the jury. So the jury's lined up like here, and you're supposed to stand at the far end, and then the witness is way at the other end, and that way the jury will just only look at the witness, and they will project, and they won't be going like this. But in fact, they'll be going like this, And it's too far away. It's like you're yelling at them and then they're yelling their answers back at you. I don't ever do that. Now, I don't go stand right next to them because then they'll only look at me and I could block the jury. But I will stand relatively close. I'm very conscious of, and all courtrooms are different. So I want to figure out, like, where am I going to be standing? So I get back up there to do the redirect. And I've been watching the jury. I'm like, what am I going to do? It wasn't a long cross. I'm getting up there to do redirect. And I lit into her.
Yeah.
I said, why are you yelling at the defense? And I just lit into her. And I became angry. Now, I got a good plaintiff verdict, and afterwards the jury said that they were very mad at me and upset that I was so mean to my client. They had nothing bad to say about my client yelling at the defense lawyer because they had forgotten about it because I had intervened.
Because you took it away.
You took it away.
I took it on.
Yeah.
And that's what you have to do. You have to be able to do whatever you need to do for the jury.
Yeah.
That's the difference.
Yeah.
I will always remember that because I don't even remember what I said to her. I just came out and attacked her. And the jury was just shocked.
That's a very effective technique. And
well, I wouldn't recommend it to anybody else. Like,
well, no, but what you did is what Mike just described is that you took away, your client was transitioning from being a protagonist into an antagonist, and you made yourself the antagonist, which caused the jury to want to protect the client.
Yes.
And I think that's an effective technique in trying to draw back and shift energy.
But it wasn't something that you would ever learn in law school.
No.
It was not appropriate exam. I mean, everything I said was fine, but it wasn't.
Yeah.
It wasn't a textbook. A textbook wouldn't tell you that. There's this thing that you have to do in trial, that is read the room and be present, and most lawyers have a very hard time doing that.
Oh boy, that's true.
And when you hear the term multitasking, that is a hard term. Most people will say they can multitask, but most people can't. And even the people that can multitask, it's never as good as just having one thing that you could focus on. However, I pretty much can multitask. And that allowed me to be able to do that. Now, maybe I could do it better if I only had, 2 things instead of 4 things to be considered, because I had a whole other list of things that I could have also talked about, address things on the merits more, or done something else. Yeah. But being able to read that room, so it's an emotional thing.
Yeah.
So I'm going to give you one more example. So, it's happened twice to me.
Okay.
It happened in 2 different cases where I had a horrendous eyewitness. Horrendous, was going to kill the case. The first case, the eyewitness was following another vehicle going the other way. So my client was coming towards them, and the witness was behind the vehicle that crossed the center line, hit him. This is the fire truck case. I think I told you, the ambulance case. And what I did was, in deposition, I had to map it out, but then I had the wrong map. I didn't mean to really confuse things, but I had things all kind of mixed up, and the witness got very upset and angry with me. And then I said, I find out all the I don't knows, like what color was the car? I don't know. What time of day? I get all the I don't knows, but I'm sprinkling them all through the deposition. I don't ask them all one at a time. I'm getting all these I don't knows. And then very specific. And then I said, well, what happened after the crash? You ran out to her aid. No, I didn't. Why not? Well, I'm scared of blood. Oh, you didn't go because you're scared of blood? But, you were the first one that could have gotten there? What did you do instead? So when we got to trial, I called the witness because I needed to. He is a most troubling witness. And what do you think I did?
What did you do?
Well, first of all,
all the I don't knows in a row right away.
I did all the I don't knows, but the second thing I did is I asked him to diagram the incident, and he refused. Now, he refused because the last time it happened in the deposition, he got angry at me because I was using the wrong diagram and he had to redo it. And he thought I was trying to confuse him and mislead him. And I'm like, I'm so sorry. I'm just, sometimes I just don't get things right, But I knew I had triggered him. So he refused. But the jury doesn't know anything about the history.
Yeah.
They're just like, this guy won't even draw a simple diagram. He refused to do it. And then I said, why didn't you go and check on her? And he said, well, no, I didn't go check on her. Why not? Well, I was scared of the blood. I mean, those things, they disbelieved him entirely.
It was a refusal to cooperate and draw a diagram.
So this next witness, which was the motorcycle case, who said that my client was going 80 or 90 miles per hour before impact, and he was a FAA guy, so he was a person that's used to tracking relative speeds.
Speed to distance, yeah.
I mean, this is a disaster, right? Could be. But I'd taken his deposition, and I had pissed him off. And I can't even remember why, but I knew why. And I had also asked him all the I don't knows, which there ends up being like 20 of them. And when you put them all together, they're great.
Yeah, that looks really bad when you have them all in a row.
However, what's even better is my first question to him when he got up on the stand. He got up on the stand. He was very angry to be there. Again, he hated me in deposition. He was very angry to be there. And, actually, he wasn't even there. It was by Zoom. He refused to come. And the first question I said...
What was the first question?
Did you tell my staff to F off when they tried to bring you here to court?
What?
And he went off.
What did he go off?
What
did he say?
I don't need to be here. How dare you make me come to court? He went crazy.
Oh my
and
God.
Then the whole thing was a battle. And the jury hated him. He was disrespectful to me. He was disrespectful to the judge. The judge wanted me to end it, and I'm like, yeah, I'm not ending this. I'm keeping going. It was horrible testimony.
Well, what you're talking
But
How did the jury react to that?
Well, I was just as sweet as, and all the time, for each of these, I'm just as sweet as calm, and like, I have no idea what's going on. I mean, I don't know what's happening here. What? I mean, the louder they get, the quieter I get. The softer I get. And I just let him do it. The jury hated him, disregarded him.
You're describing techniques that you're using with friendly witnesses and adverse witnesses, and this gentleman was both adverse witnesses. And that the setup for the examination occurred in the deposition. You understood what his temperament was, you understood what the trigger was, and then you went in and used the trigger to have him diminish his credibility in front of the jury and ultimately discredit him and discredit the defense.
In a very sweet way.
In a sweet way.
Yeah.
And yet, no, that's not taught in law school, no.
But how do you even do that? Like, your first question is literally going to be, did you tell my staff to F off?
Well, I mean, when you do that...
First of all, Rory Lee did not see that coming and didn't object to it.
Yeah.
But, it goes to motivation and why you're there. It's completely not irrelevant.
No, I think it's totally relevant. It's relevant.
He's a combative witness.
Yeah.
I just wanted to set that record straight, and I did.
Yeah.
So those are some examples of things that you cannot prepare for this. Like, people over prepare so much in trial, and I think that you should prepare. Like, it's not that I don't prepare. I prepared, but if you don't give yourself space, you can't see the courtroom.
I totally agree.
Let's talk about seeing the courtroom, because for me, the most important part about examination is how it lands. It's not how the witness is even doing.
Yeah.
They can be doing technically everything perfectly. It's, do these people seem to care?
Well, that's the most important thing, is what the jury's thinking.
But most people can't see the jury, or they're not focusing on the jury. They're wanting to make sure that the answers are correct.
Yeah.
Yeah, they can't do that.
Yeah. I mean, for me, it's a couple of things. One, law school didn't teach me how to move and be in a courtroom or how to examine witnesses.
Let's talk about being and moving in a courtroom, especially in the context of a direct exam. I talked a little bit about my placement is typically fairly close to the witness, not on top of them, but in an intimate setting, like we're having a conversation. I'm having a conversation.
Yeah.
And and they always say, "Would you please speak up?" Or I have to hold a microphone or something like that. And I don't care. I'm happy to do either. But you don't ever have to be told to speak up because you are very loud.
Yes.
But talk to us about body, voice. Where do you go in the courtroom when you're examining witness?
Well, first, I'm a Meisner-trained actor. I was in New York. I was an actor. I was a writer. So
Wait a minute. Meisner is who?
Sandy Meisner. He is like Stella Adler, who is a technique of learning how to act. And Meisner training
Show us.
I can show you.
Okay, wait. Who are you going to be?
Who are you going to be?
I don't know. You're leading this.
No, you're leading this.
I am. Who should I be?
You can be whoever you want. We're doing Meisner right now. That's Meisner.
Yeah, that's what I was going to say. He's already doing it.
I'm doing it. So the Meisner technique, there's the Adler technique, which is what's called the method acting, which is you tap into an experience that you know well, and you call on to that experience from a historical experience, could be trauma, and you rely on that to be in character. Meisner is about listening to understand, as opposed to listening to want to respond.
Wait, repeat that and explain.
Okay, you're listening to the person to understand where they're at and what they're saying. Mm-hmm. And then when you understand, then you respond. So in a setting of a courtroom, it translates actually really well. It's a technique that I used to practice when I bartended. So I used to work on roles, and when I'd go, to auditions, I would just use the technique while I served people drinks. So when I do an examination...
Like what? Like, can I have a rum Coke?
What's your name?
Sally.
Sally. Where are you from?
Houston.
Houston? When did you come to New York City?
When did you come to New York City?
I've been here since 2000.
Oh, well, I was there since 2005.
Do you like New York City?
Yeah, do you?
I love it. Why do you like New York City?
Well, because I can meet fun people like you.
So what we're just doing is that we're having an intimate conversation and we're building rapport. What juries want, what audiences want, is they want to get inside an intimate relationship. They want to get to know people. And you can use this technique to get the jury to know you. Because ultimately, you're going to go talk to the jury in closing. And they got to trust you. You can talk to them, or they can get to know you through watching you have conversation with somebody else. And so my approach is to have a conversation, an intimate conversation with a witness, and let the jury within that conversation. Now, sometimes these are what I'm talking about are friendly witnesses. And for example, in the Taylor trial, if you go back and watch my examination of Summer's brother, my entire examination was based on this technique, was getting to know him, and he getting to know me, and the jury getting insight into that. Now, my movements are intentional. You will see me move in a courtroom between questions I ask, because I'm creating distance between myself and the jury, coming closer to them. I'm actually trying to create physical intimacy with the jury so that the jury trusts me the closer I get to them. And the witness, the same way.
He's more calculated than I am.
I mean...
I'm very intuitive. I'm feeling it. I feel it if they like me or don't like me, if they're leaning in or not. Something about me, I can tell the micro movements. I can feel it really well. It's always been a pretty good strength of mine. I can tell when they don't like me and when I'm going to be in trouble.
You're talking about they don't like you. Who's that?
The jury. I'm only talking about the jury.
Okay.
But so I'm not intentional.
Well, I guess.
As you are.
Well, I wouldn't say I'm intentional.
You just said you were intentional.
Well, I'm saying, okay, let me reframe.
Quote unquote.
I'm
Every movement I make is intentional, end of quote.
Okay, fair. But it is, but I can tell you right now that you can't tell that I'm being intentional. No one is able to tell what the hell I'm doing. No one's able to sit back and go, oh, that's dumb.
Now I know.
Well, now you know,
He's
but
doing the walk.
no one's going to be able to go, oh, yeah, that's Meisner. That's what that guy is doing. No one's going to be able to tell that.
Well, now they all know.
Well, yeah, now they know. But the second thing is that you can get people to like you through this process if they don't like you. You can get them at a minimum to trust what you're saying. It is through the intimacy. I am telling you, it's creating intimate moments between a witness and yourself. Now, strategy-wise, what I'll do is if I interview a witness before they take the stand, and let's say they are an adverse witness, I will be very aggressive with them outside of the courtroom. Okay? And then when I come into the courtroom, I flip.
Same exact.
Same.
That's what I just explained. Yeah.
Yeah. So that approach, it's very effective. It throws the witness off, and then they start to just give you things that they would not have otherwise given you because they just don't want to have a confrontation with you.
Here's a question. What do you do when you're presented with not a hostile adverse witness, but a experienced expert witness who is good at, I guess I would call it, manipulating their testimony?
Well, we weren't going to talk about experts, but it's still a good question. So we'll segue and talk about the expert. So for me, there's a little bit more preparation involved. We would have taken their deposition.
Yeah.
But now I'm on a kick of taking it for no more than an hour. And mainly I just want to do the ones that I don't know so I can understand, like, how am I going to get under their skin? I want to get under their skin real quick and see what their push points are. So for me, it's more tactile, like emotionally. I'm looking for what can they tolerate or not? Where are they going to go? How good are they going to be at staying neutral? Like Bill Parton, who I hate so much, who's finally retired, economist, who used to say that this person was worth more dead than they were alive, literally.
That's horrible.
Anyway, he was pretty good at trying to act like he was never bothered, but I could always bother him. And it's similar to what he's saying. Like, where are their soft, squishy points? But you also want to do it. There's some people that think that they can just take on an expert on every point. That is never good.
No.
You have to have, what do you want to get out of your cross? What is the 1 point or 2 points, maybe 3 points that you want? You don't want to take them through all their opinions and then refute them. Like, that is horribly boring. You have to have a real concrete idea, normally ahead of time, of what those points are.
I don't think experts generally make or break a case. I think that what experts, when they're put on well,
they do in medical negligence cases.
Well, generally, I said.
Yeah.
Not in every. I'm just said generally speaking. I don't think experts make or break a case, but I think that what I try to do is, with my experts, I always tell them, you're a teacher. You're not an expert. So if you're educating, the jury's going to like you and connect with you. So what I try to do with the other experts is make sure that they don't look like educators, that they look like something else. And so a good way to confront and impeach an expert is to demonstrate that they're not a good teacher. They've not done all their homework, or they're not looking at all the information. And then you something as simple as that causes people to be skeptical of people who hold themselves out as experts. I mean, a lot of the times what I've seen in the defense experts is that some medical defense experts don't even examine the client. I mean, that's such an easy thing to sort of impeach an expert on.
This could be his whole topic, but one of my favorite things to do with experts, and it's very difficult because there's a fine line. You don't want to co-sign on that expert, but is to co-opt Some people call it hijack the expert, co-opt the expert, which is just figure out how they're going to endorse your case and get a second whack at it. In fact, it's one of my favorite ways to use a defense expert is to verify, the points that I need in my case in chief.
Well,
Get them to endorse them.
That's an approach, which is you find out where you agree.
You have to be very, very careful about that.
It's like, so we agree on this.
Yeah, that sounds a little dangerous too.
Yeah, but it can be very effective, especially with damages experts. Not so much with liability. With liability, less so.
I mean, when you're talking about economists, like for our clients, somebody's dead, you say, well, how much were they going to make in their natural lives? Your expert says $5 million. Their expert says $3 million. And they both have an approach. And there's not much you can do to say your approach is not as good as mine, or you can do some things. Ultimately, my experience is the jury splits the difference or something along those lines. It's hard to sell on that. But I think that when you're talking about a medical examination or a psychological examination, and you have an expert come in and say, here's my psychological opinion, your client does not suffer from X. I go, well, have you examined them? Have you spent time with them? And they go, no, I looked at the records. And then you say, that's an easy one with the jury. You go, could you imagine somebody giving you an opinion, a medical opinion, without even having a visit with you? And just reading your records and saying this is what's happening with you? That's an easy one, I think.
There's normally a direct relationship between if a jury is going to go with you and have you win the case and which side of the economics they give you. They don't often split the baby. Sometimes they will, but normally if you're going to get a plaintiff verdict, they're going to go with the plaintiff economist. And if you're going to get a bad verdict or lesser verdict, they're going to go with the other economist. In general, there's some weird things about economist testimony. Anyway, is a weird thing. We could talk about that separately.
Yeah, sorry to derail you with experts a little too much.
No problem.
Yeah, but let's talk just really quickly. Some of the best testimony in the world is lay witness testimony, and that's family, friends, coworkers, people from community, church, work. Those people are so good because the more they testify, the less the plaintiff has to testify. So if there's one lesson to take away from here is people put on the plaintiff for way too long.
Yeah.
Way too long. Sweet spot, 25 to 35 minutes or less.
Yeah.
Sweet spot. When you have everyone else doing it, then the plaintiff doesn't have to do it. And who wants to, you're basically asking them to prove your own case. So I want to talk just a little bit about plaintiff. So I talked to you about lists. I'm super against lists because it creates anxiety for the witness, especially a plaintiff. They got this list, they got to remember all these rules, and then they got to memorize a script. And then, you put so much on them. And the way that I prep a plaintiff witness is completely different. I say, I'm Oprah and you're my guest. Or I say, I'm your neighbor and we're going to be catching up. That's the tone that we have here.
Yeah.
I'm going to ask questions and you're going to answer them. If you give a bad answer, that's my fault for not asking you the right question. I'm a good lawyer. I will only ask you good questions.
Yeah.
And when I teach this, I tell lawyers who complain about, the plaintiff did a bad job. You did a bad job. It's your fault. If you'd asked the right questions in the right way, then the plaintiff would have done a good job. So when I've had plaintiffs that haven't done a good job, and there have been some, I take responsibility for that. That did not go well. And I've had some where they weren't prepped enough. Normally, I prep quite a bit. Do them by videotape. I have multiple meetings. We've already been together the whole case. They have an idea of how to do it. But I don't want to script it, and I don't want to overwhelm them, and I certainly don't want them to be so tired by the time that it comes that they just talk rote.
Yeah.
And then there's two types of plaintiffs, witnesses, general. There's the stoic, and then there's the one that is the opposite of stoic, that can describe exactly how burning and stabbing that pain is with the exact amount of frequency, that has an encyclopedic knowledge of every indignation that they have, indignity that they have experienced or loss that they've had, and they could go on for days. The juries will always like the stoical. They will always. And so if you're using lay witnesses, it's fine because they're testifying for that guy or guy meaning guy, or guy for me is like gender neutral. That's what a jury connects with, because they're not sitting there trying to prove their case or whining in jury's terminology. The other witness is way more difficult. And with that witness, I want them on as short as possible.
And with lay witnesses, what they end up doing is they become what I call, you're not allowed to put on character testimony, but lay witnesses provide context to client character because they describe them in day-to-day life. And because the jury feels a lot of the times that your client has been prepped.
Yeah.
And so you're absolutely right that lay people are essential. People who see them, that they do the same things as ordinary people and experiences. I think that's...
But you're not quite there. What I like about the lay witness isn't just the data. I don't like the data. The data to me doesn't mean anything. What they're getting from those lay witnesses, you can tell when a lay witness loves the person or cares about them. Or I always ask them to tell us stories. I don't want to hear like they could do this and now they can't do this. I want it all in story version. Once we went and did this and then this happened and da-da-da-da-da. I want the story. I only want stories. But there's a warmth, there's a love, there's that emotional connection that lay witness has with the plaintiff, that it's more than character. It's like illustrating that the person is, everything comes back to love, Mo. The person is loved.
Yes.
That's, you call it human connection, but I call it's that deeper thing. It's the love for that person.
Don't you also think, though, that people respond more when they're hearing it not from the witness, like you said, but from their friend? Like, I mean, if you recommend a movie to someone, they're going to be more apt to believe what you're saying than they would from the advertisement for the movie.
Yeah.
People want to make that connection. And you can't always get it from who you think, like you said, you think they're prepared, or you think they're lying, or you think they don't remember correctly, or whatever. But if you get it from somebody else, even if it's exactly the same thing, you're going to believe that a little bit more.
And jurors want to make the right decisions.
Yeah.
And so they don't want to be misled or have someone exaggerate something. So the more that you have these touch points for them, the more comfortable they come of who this person is.
I agree with that.
Okay, but we need something exciting to end this.
I think what we can end with the exciting is that about witness examination.
Well, that's what we're talking about.
I think the exciting thing is like I've had a witness lie, and I've caught him in a lie.
Yeah.
Oh, your witness, or
it was an adverse
defense
witness, and I caught him in a lie, and it was a bad lie, and then I was graceful in outing the lie, and the jury liked that more because the jury knew that the witness lied, and because I was graceful, it worked much more to my advantage than had I been more like, you're a liar. So sometimes I think like doing the obvious, you shouldn't do it.
And this is when I get irritated and jealous listening to someone like Mo talk about this, because it's so much harder for a female trial lawyer to do a lot of this stuff.
Can you tell me more? I'm interested in that.
Yeah. For example, I've had many witnesses lie, and I've caught him with the lies. And sometimes I become aggressive. And then later the jury says, you were too aggressive. they don't like that. You have to be very careful when you're a female trial attorney
So what
with
you're
your
saying
emotions. I've had them also say the opposite. Why weren't you harder on that person? You should have been harder on
You're
that
too
person.
soft.
And so for a female trial attorney, you are constantly navigating and having to be very conscientious how you do things. I have come to the realization, which is probably a good realization anyway,
Yeah.
that for me what works is, and you probably heard me say this, I need permission from the jury before I will become anything other than kind. I need to feel the jury saying, okay, that ticked us off. We think that guy's lying. You should go.
How do you do that? How do you know you have permission? Just intuition?
Yeah,
I
it's a
have to
feeling.
pay
a feeling.
attention,
Yeah.
and you can tell they start going like this. They start crossing their arms. Some of them will be shaking their head. You should see how many people shake their heads. It's not hard to see it, and then you can go. Especially if you start feeling them losing their temper.
Yeah.
Then you have to make the decision: do I just not lose my temper? Well, obviously you're not going to lose your temper, but am I going to go after this, or am I going to just stay way, way back in the friendly zone, or am I going to get, there's a whole range. It's not just sweet and attack.
Yeah.
There's a whole range of stuff that you do in between there, but I am very much tuned into the jury.
So I think that would be a good topic next time. I really want to explore more the gender dynamics of trying a case.
Wow.
I think that would be a good one. I want to talk about the trial.
Let me
in
count the
every
ways.
respect. Yeah, that was a good. Okay.